If you had to judge yourself, how would you judge yourself? In the last few months of your tenure, you came under inordinate scrutiny and a certain degree of not so kind trolling.
Yes, it does hurt when you realize that, people are critiquing you for the wrong reasons.
There are some senior lawyers who have been very critical of you.
I'll only ask some of them this question. What did you do when you were on the bench?
And I remember interviewing Fali Nariman just, I guess, a few months before he died. Why didn't the Supreme Court tackle the question of whether a state can be converted to a union territory?
Article 3 of the Constitution is not as clear as you would imagine it to be. Article, can I just show you a very interesting part?
Please. As a judge, how do you navigate faith?
Our Constitution does not mandate that judges must be irreligious or agnostic or atheist in order to be independent.
Is Ram Rahim, who is standing trial for rape, getting multiple parole visits because he's politically powerful, and in Umar Khalid...
Can you imagine that the case was adjourned? There were at least 7, if not more, adjournments which were sought by the counsel appearing for Umar Khalid.
You have such a calm, measured way of speaking, but in court, you often lose your temper.
You're 1 second.
I am a citizen of this country.
1 second.
Yes.
Don't shout at me.
No, I am very soft.
Often to nahi, but sometimes.
Dearly?
How does a person retain her or his rootedness, your central balance, with so much praise and so much criticism?
I have my own ways to switch off.
ABBA and Dylan, I believe.
Yes, of course.
Thank you so much, Justice Chandrachud, for your time.
Pleasure to be here.
You spoke at a convocation in Bhutan just before you retired, about how you were ridden with fears and anxieties, how you wondered how history may judge you. If you had to judge yourself, because in the end, above everything, all of us are answerable to ourselves and our conscience. If you had to judge yourself, how would you judge yourself?
If I have to judge myself, I would say that, I decided every case that came up before me, true to my conscience, and applying fundamental yardsticks of the Constitution and the rule of law, which I was bound to apply as a judge. I also tried to bring in as much as I could, consistent with law, things which are very close to my heart, which is compassion, standing up for the marginalized segments of our society, doing work on gender. These were some of the issues which were very close to my heart. Disability and the rights of, the differently abled citizens. But overall, I think that's how I would like my legacy to be. Of course, at the end of it all, it's for others to judge, and I'm not going to be judging myself. Because you take a decision which at that particular moment in your life as a judge appears to be the correct or the just decision. Well, it's thereafter for posterity and for contemporary and later societies to judge the impact of what we have decided.
In the last few months of your tenure, you came under inordinate scrutiny and a certain degree of not so kind trolling and social media commentary. What is your coping mechanism? Do you make it a point to not read what they say about you? They can be anybody. Or do you have a fair awareness of how people are commenting and have grown a rhino-like skin over the years?
Well, I don't have a rhino-like skin. And I would never like to.
Does it hurt?
I wouldn't ever like to have a rhino-like skin anyways, because I'm a vegan. And,
I was using it strictly as a metaphor.
I know. But honestly, Barkha, I'm aware of what's on social media. I'm not on social media. I never operated social media.
Would you come on social media now?
Haven't thought of it, honestly. It's too early after my having demitted office as Chief Justice of India. But at the end of it, I also believe in the power of free speech.
Yeah.
And if you do believe in the power of free speech, you must give that liberty to others as well. Free speech doesn't only operate when you speak about others. It also operates when others speak about you. But so very often I found that, so much of the criticism was completely unfounded. People don't have time to read a whole judgment. They don't have time to place what was said in context. But then that's probably a new normal of the age in which we live.
Yeah.
And we have to accept that as citizens, as judges when I was a judge. So though I felt that a lot of the criticism, in fact, most of it, was unfounded, it was targeted against an individual and not the verdict or the work.
Why do you think they were targeting you? See, there's a difference between free speech and defamatory slander. And I'm, of course, not advocating for any sort of crackdown by you. But when you say that they were targeting you as an individual, why do you think that was? And I ask you this is, obviously, I can't compare myself to the Chief Justice of India. But as people who live in the public eye, this is the new normal. We face all sorts of commentary about ourselves. I'm just wondering, when it really feels at odds with the truth, what do you tell yourself?
Well, I tell myself that I have to continue to do the mission or the work which I had assigned for myself, the mission which I have carved out for myself, because it's all too easy, Barkha, to not take tough calls as the leader of an institution, whether those tough calls are in terms of administrative decisions, whether those tough calls are in terms of the work which you do as a judge, as in terms of the cases which you decide. So the easy thing or the easy way out is not to allow yourself to be the subject matter of critique. But that's not the way I've led my life. I mean, if I had to do that, why would I have become a judge? I would have rather been at the bar and, enjoyed my freedom, appeared for diverse causes.
Made a lot more money?
Not truly very important to me. Because at the end of it, I mean, especially at my age, I've turned 65, you realize that your needs are limited and there's no end to greed if you really want to, in that sense, look at it that way.
Yeah.
And judging is a very fulfilling task. So I never laid down this for myself in terms of what would the impact of my decision on people's opinions. If you start doing that, you can't take decisions, because one thing which you have to, if you want to bring about transformation in an institution or to use the transformative power of the law, obviously there are going to be two views. There'll be scope for critique, but you're looking about, where you want our society to go towards in the next 25, 30, 50 years. And there's obviously going to be a scope for difference of opinion. So I take that with a great deal of humility, that people are entitled to critique. Yes, it does hurt when you realize that, people are critiquing you for the wrong reasons, or it's an effort to target you personally. Why a few people have targeted me personally, I think we better ask them, not me. I don't want to even think about it.
There are some senior lawyers who have been very critical of you, Dutt, for instance.
But
when you meet them, I've always been curious. Suppose you meet them at a wedding. Somebody who's been really sort of very critical of you. Do you still say hello?
Well, of course. Why not? I mean, I respect the right. I respect their right to be critical. And in fact, I always believe that, if you're true to your conscience and true to yourself, you look at every criticism and ask yourself, is there a room for improvement? Could I do it differently? Is there some merit in what is being said by someone, however unfounded that criticism may prima facie appear to be? So there's no question about not observing social niceties and things like that. But my faith lies in this, that for the few who have spoken, as you've mentioned, there's this large mass of litigants who continue to write to me now that I've ceased to be a judge, where, the old barriers of, protocol and everything have been lifted. I get emails from people whose lives I have touched, young members of the bar who come and drop in, people who I meet outside now that I can mix freely in society. So that brings you a sense of, faith in the system, notwithstanding a few voices, on the other side.
I guess my question is, how do you remain centered? Because you were, you were seen to be, you were a celebrity judge. One, you had a long tenure. And so, people who come for just a few months, they don't have the time to really sort of build a reputation or a commentary around yourself. And liberals and conservatives both had very strong opinions about you. You were often called a rock star Chief Justice, and then you were also called all sorts of other negative things. The question is, psychologically, how does a person retain her or his rootedness, your central balance, with so much praise and so much criticism?
It's a tough world. And it's a tough world even for a judge to navigate, particularly in today's times. Even more difficult if you are leading the institution.
Yeah.
All of us have our own paths to maintain your sense of equanimity, because the court is an arena of conflict.
Yes.
People don't come to court if there's no conflict.
That's right.
So whether it's a dispute between two spouses, between two partners, between two corporate houses, or between two levels of government, the state and the center, or the center and the citizen, there is essentially a deep-rooted conflict which comes to the court. And that conflict does, of course, spill over into your own sense of equilibrium, because you carry it home. If you're dealing with a case involving the award of the death penalty, obviously you're going back home in the night and asking yourself, was this the correct way to go about it? And you take that decision at that particular point of time. But having said that, I think what is the greatest solace is when you apply fundamental principles which are dear to our institution and to the nation and to our society, on which the whole democratic edifice is founded. Principles which are based on human dignity, the equality of citizens, fundamental principles of liberty. And of course, there's a degree of balancing which you have to do as a judge, even in the course of applying those principles, because no one principle is absolute. What may appear to be a case for equality to a citizen, for another may be a violation of their equality. Liberty to one may be a violation of the liberty of someone else. So you're doing this act of balancing continuously in the court. At the end of it, of course, you have your own personal ways to keep rooted. For me, I spent some time, I've been an exercise buff. I've been doing yoga for over 20 years.
Do you do it every day?
Yes. Except, when you have a little problem with your back or your lower back, in which case you are off it for a few weeks.
Midlife blues.
Yes, absolutely. So I have my own ways to switch off, which was very early in the morning before my day began, which I thought brought me a degree of equilibrium, association with very close friends. I have just a handful of close friends. That's one of the problems of being a judge, that you can't have friends across the spectrum.
That's right.
But,
and ABBA and Dylan, I believe.
Yes, of course. And the Beatles.
And the Beatles.
But also the newer genre like Adele.
Really?
Yes.
Did your daughters introduce you to Adele, or did you sort of discover her yourself?
I discovered Adele myself, but my daughters would continuously be loading my cell phone.
Your playlist?
With improving on my playlist, or adding something which, the girls like. So they're very fond of music.
Yeah.
So they'd be adding to my...
Do you have a favorite Adele track? Rolling in the Deep would quite describe your life. But, a lot of people have spoken...
Or Fire to the Rain.
Fire to the Rain. That's my favorite, by the way. A lot of interviewers have spoken to you about your verdicts, and I will come to those. But I was, when I was reading up on a lot of your judgments, I found the dissents quite interesting. I think there's not enough focus on the judgments in which you have dissented. So I actually want to start there. And I listed a few. Aadhaar. I don't know how many people remember that you had a dissenting note in Aadhaar and you actually questioned whether there was informed consent. Sabrimala, because you said it was not for the court to decide what's an essential religious practice, right? These were two that really stand out. Also the Bhima Koregaon case, where you believe that the police investigation had infirmities and the petitioners had a right to a different sort of supervision of the police investigation. I don't know that enough attention is paid to the moments that you expressed a rebellion within the constitutional framework. When you look back at these dissent notes, were you disappointed that you couldn't drive those verdicts in a different direction, or the court didn't go in a different direction on these?
Well, some of them I would have anticipated that I would be the lone ranger. on the
Aadhaar
other
in
side.
particular?
Absolutely, because when arguments are going on in the court, of course, the bar assesses judges from the perspective of what you are discussing and so on and so forth. But between ourselves, we are continuously in a dialogue. When we get off the bench, when we are meeting in chambers, we're waiting for a hearing. All the judges assemble in the Chief Justice's chamber before and after usually for a cup of coffee. So you're discussing the lines of possible conclusion. So as the head of a bench particularly, and the other judges as well, you're conscious of the way the case may be eventually unfolding. So it's not too much of a surprise that you're taking a particular position. But for me, a dissent in that sense was a matter of principle. I also dissented, in the marriage equality case.
That's right.
Where I said we must at least recognize the right to form unions.
And also to adopt children.
And to adopt children. So in that sense, a dissent is really an appeal to the present and to the future. Because these issues which we decide, and many of these which you mentioned were so important from the perspective of, the future course of our society, that I thought that, well, even if I'm just the sole individual who is striking a different note, I have to say that, because ultimately what a judge is known for, or the difference which you make to society, is through the written word, because that is what you lay down for the future. And therefore, it's critical for a judge to write and to speak their mind through their written work. And therefore, whether it was Aadhaar, it was Bhima Koregaon, or, so many of the other cases where I have dissented, including something as innocuous as whether, in a matrimonial dispute, should mediation be allowed through technology? Two of my colleagues said that, no, you can't have technology. It must be a face-to-face mediation.
Yeah.
And I said, good heavens. I mean, if one of the partners is situated in Silicon Valley and the other one is in Bangalore, how can you have both of them coming face-to-face? I mean, they'd be giving up a week of work and then attempting some mediation. So each one of these cases really, in that sense, to my mind, speaks to what my vision of the good society for the future was.
So do you continue to have serious concerns about Aadhaar violating the right to privacy, which was one of your key judgments?
Actually, I looked at it from a doctrinal perspective. I also see now, over the last, several years, as the benefits of Aadhaar
of course, they're tremendous.
have percolated down to our society. And therefore, I wouldn't take that away at all from the Aadhaar project, just in terms of, what it has done to ensure that social welfare benefits particularly are made available directly to our citizens, the direct benefit transfers, for instance. So I don't take away for a moment the benefits of the Aadhaar scheme. But from my point of view, the Aadhaar scheme did not introduce adequate safeguards for the preservation of privacy. And that was the core of my dissent, because particularly today, as we are now moving into an age which is governed so much more by AI, and every aspect of our lives, we lead electronic footprints in whatever we do. Whether it's ordering a meal on Swiggy, or ordering a book on Amazon, or on Kindle. So you're constantly being watched. Not watched necessarily by the government, but watched by Big Brother, which could be
the new 1984.
Absolutely.
Yeah.
So particularly in today's highly interconnected and networked world, governed as we are by now by AI, it's important that we preserve the core of individuality. Otherwise, every little aspect of our lives is almost in the public realm.
So you think Aadhaar is a great scheme, but it should have more citizen rights in terms of safeguarding privacy and also understanding consent?
Oh, absolutely. And that's the essence of my dissent.
Yeah.
And therefore, even going forward, what we can learn from the experiences with Aadhaar is that as we adopt more and more such schemes, we have to introduce adequate safeguards to preserve the sanctity of individual lives and the privacy. And I don't think it would be a correct postulate to say that merely because an individual is not affluent, that therefore you're willing to forsake your privacy. The argument on the other side was that, well, all this is a very, very elitist concept. And I said, no.
Yeah.
Valuing privacy is something which has nothing to do with social class. You need to preserve that element of, the privacy of every single individual in society, irrespective of the class to which they belong.
Yeah. The Bhima Koregaon case saw reasonably high-profile activists spend a long time in prison. Sudha Bhardwaj, Stan Swamy then dies while this case is still ongoing. Your note of dissent is, of course, well recorded, but it also raises larger questions about one of the key criticisms, not of you in particular, but of the court on bail, right? You have famously said that you have personally given bail from A to Z, Arnab to Zubair. People have argued that it all depends on which judge hears the matter, and you might be liberal on bail, you might be inclined to give bail, but when the case doesn't go to you, then what happens? And an instance that is cited again and again is that of Umar Khalid. So you did the A to Z, but what about the U? Now, I don't mean to make this about one individual, but I'm using him as an example of how there are cases like that contradict your own belief that bail should be the norm and not the exception. Do you have some regret that there were cases like that just weren't actioned in a time frame?
Barkha, I must mention this, that after I took over as the Chief Justice of India, we look at it from the systemic perspective and then answer, individual issues that you have raised. I thought we have to prioritize cases relating to bail and preventive detention. And family cases involving transfer of proceedings, particularly between conflicting spouses. So every single day, apart from Mondays and Fridays when every judge does a whole lot of bail applications, all the other days, every bench was assigned at least 10 bail applications to give them the highest priority. And in the last year, before I demitted office, 21,000 odd bail applications were filed and 21,358 bail applications were disposed of. So at a macro level, at a systemic level, you see that the Supreme Court has been extraordinarily proactive in attending to cases dealing with bail. Now, coming down to specifics, a particular case or couple of cases.
Start with Bhima Koregaon because your dissent note is on record there.
Of course. Now, one thing you have to understand is that the Supreme Court is, as it is called academically, a polyvocal court.
Right.
Right? We are not like the US Supreme Court where 9 judges sit en banc. That was not the model which our founding fathers and mothers adopted when the Constitution was framed. So we have now, at any given point of time, about 16 or 17 benches, 34 judges. Chief Justice sits normally in a bench of 3. Or even if the Chief Justice sits in a bench of 2, you can't have more than 17 benches. Now, therefore, when you have a polyvocal court, there has to be a degree of acceptability of the fact that, yes, all judges are conscious of the fundamental principles underlying the grant of bail, which is a presumption of innocence. 2, the parameters for the grant or denial of bail are extraordinarily well settled. But at the end of it, whether a decision to grant bail would be made would depend upon how that court feels at that particular moment.
But you're the master of the roster, right?
It doesn't work like that. Barkha, can I deal with that straight away, the master of the roster issue?
Yeah.
Individual cases are never assigned by the Chief Justice to individual judges. The way it works is this in the Supreme Court. The Chief Justice provides for the roster in the sense, say judges, court numbers 1, 3, 7 would be dealing with direct tax cases. Almost all judges in the Supreme Court deal with criminal cases because the largest inflow into the Supreme Court is of criminal cases. So the roster includes almost 99% of the benches would deal with criminal cases. I said 99% because sometimes the tax bench may not deal with a criminal case because you want that tax judge to be doing only the revenue cases, right? Now, what happens is once the roster is published under the authority of the Chief Justice, and it's periodically revised after 6 months or when there's a retirement because that roster of the retiring judge has to be assigned to other courts. Within the roster, the allotment is made randomly by the computer. It's not that. You wouldn't be able to do that. Physically, it's impossible for the Chief Justice. There are about 1,000 new cases which are coming into the court every week. About 1,100 cases are being assigned to judges. If the Chief Justice started assigning 1,100 cases, there would be no other work which the Chief Justice would do. The area where the Chief Justice does have a discretion is, for instance, where a judge feels that, well, this case has come to me under the computer allocation, but I believe that another colleague has dealt with the same issue.
Right.
In which case, let the papers be placed before the Chief Justice to assign this case to that other judge. Alternately, if a judge recuses, or if there's a divergence between two benches, in which case, the benches will say that please place the papers before the Chief Justice so that the Chief Justice can constitute a bench so that this divergence can be resolved. That's the area where the Chief Justice really has an element of discretion. So ultimately, cases are allotted in terms of a random allocation. Now, this I have learned as a lawyer, even when I was a lawyer appearing before the High Court. We had judges who were very liberal in terms of, say, rights of labor. Other judges felt that there was a greater need for discipline in the industrial workplace. There were judges who were more liberal in the grant of bail. There were judges, this thing about liberal and conservative is not the politically liberal and conservative. It's just the way judges exercise their discretion. Second, when we are talking about the grant of bail, it's always important to understand that there's not merely the presumption of innocence of the accused, but the wider societal interest as well.
Right.
Namely, the need to protect society against crime. I'm not dealing with any particular case here. Now, every judge, while taking this decision, has to basically look at a few things. First, is there a prima facie case? Two, what is the stage of the trial? Is the trial likely to be interminably delayed, in which case you don't want to keep a human being behind bars? Third, is there a likelihood of the accused fleeing from justice? Fourth, is there a likelihood that the person, if they are released on bail, may tamper with the evidence during the course of the trial? Now, these are some of the issues which are dealt with by judges. I'll give you another example. You deal with these NDPS cases. Now, most of these drug cases, or a large number of them, deal with petty offenders, a truck driver, a cleaner. Now, there are very stringent provisions under the NDPS Act governing the grant or denial of bail. Now, notwithstanding that, we ask ourselves as judges a fundamental question. How long is this trial going to take? How many witnesses are there? Are there, say, 50 witnesses? Is there any chance of the trial being concluded within a reasonable period? If there is no chance of the trial being concluded within a reasonable period, you have to grant bail, notwithstanding the stringent provisions of the law, because Article 21 of the Constitution is fundamental. And to my mind, this is a basic principle which every bench should and does apply. Now, within that spectrum, obviously you have different people deciding cases with their own experiences
with their own
of
lens.
life.
So what happens is, what the layperson sees is a Ram Rahim who is standing trial for rape, getting multiple parole visits because he's politically powerful. And in Umar Khalid, this is what the layperson sees. Now, this may be, as you've explained it, the lens of that particular judge, the lens of that particular court. But there seems to be a great unevenness in which this principle is applied. Would you concede that?
Not really. Now, since you mentioned Umar Khalid's case, and I don't want to comment on the merits of the case.
Yeah, I'm not commenting. I'm using it as an example.
But I must tell you one thing which is lost sight of by a lot of people when it comes to Umar Khalid's case. Can you imagine that the case was adjourned? There were at least 7, if not more, adjournments, which were sought by the council appearing for Umar Khalid, and eventually the application for bail was withdrawn. So what do you have to say to this? That when, on the one hand, lawyers appearing for the accused repeatedly ask for adjournments of cases before a judge, and then you withdraw a case, can then everybody, can a segment of the bar or civil society say, or they must be at least told that, look at the record. Here was a case where someone appearing for the accused has repeatedly sought time before the court. Why? Why this reluctance to argue a case? Either you argue it on the first day or you say that, well, I don't want to press my application for bail. I'll reserve my application for bail before the High Court or before the district court, as the case may be. But in Umar Khalid's case itself, if the record is seen, it would show that repeated applications for adjournment was made before the court. Now, at the end of it, what happens is, particular perspective is conveyed on the social media and in the media. Judges have no place to defend themselves. And if you look at really the fine print of what happens in the court, reality is a little more nuanced than what happens.
Okay, point taken. I'll go back and look up those adjournments that you mentioned. Moving ahead, one of your most high-profile verdicts was not as Chief Justice, but the ayodhya verdict. And I'm not going to discuss that verdict because I think enough has been said on it. But what I want to ask you is, in that verdict that you are widely believed to be the author of, let me ask you, were you the author of that verdict?
Barkha, I'll tell you that.
I don't know if I'm allowed to ask that, but I'm just, because it was a verdict without a byline.
But Barkha, we all decided that the entire bench of 5 judges would speak with one voice.
But did you author it?
Therefore, there would be no attribution of authorship.
Okay. You decided to be like The Economist, basically, and have no byline on that particular
we
verdict.
decided that because this was an issue which was fraught, which had divided the polity, it had a history of conflict. Therefore, all of us must speak with one voice. Now, that being the decision of the Constitution bench, headed by the then Chief Justice, I stand by that because I'm party to the bench.
Of course.
And to now say that, well, who actually wrote the judgment would in that sense be unfair because, we all decided to speak.
That was a sidebar question. The question really is about what the verdict says about the Places of Worship Act. So if one reads the Ayodhya verdict, as I have attempted to do, the verdict is very clear in emphasizing A, the exceptionalism of this verdict, and B, talking about the importance of the Places of Worship Act and locating it within the basic structure of the Constitution. Now, what I'm leading to is perhaps one of the most debated responses by you as Chief Justice was your response to the Gyanvapi survey. And you're saying in open court that while the Places of Worship Act put a freeze on changing the religious characterization of a place of worship, it did not actually forbid the survey from happening, from ascertaining, where was this a mosque or was this a temple at one point of time. Many people believe that that observation itself opened the floodgates, sent a message down to smaller courts, led to the situation that we saw in Sambal. And the Supreme Court has now halted it and said, look, we've got to decide this matter. When you look back at that moment, do you regret that comment that you made in open court that kind of became a template for how this debate is now unfolding? Do you believe that you could have, should have halted the Gyanvapi survey?
Barkha, when the Gyanvapi case came up before the trial court ordered the survey. The High Court affirmed the view of the trial court. The case came up before the Supreme Court. The survey had been completed. In the Supreme Court, contrary to something which is again not highlighted adequately in the press or in the media, we made sure of 2 things. First and foremost, that the worship in the Gyanvapi mosque, namaz, must be allowed to continue as before. We issued strict directions to the collector and district magistrate of Varanasi to ensure that worship in the mosque is not impeded in any manner, including the antecedent places like the wuzu, where the other rituals are done in the mosque. That was one aspect. We prevented the carbon dating of the particular site where the plaintiff's claim was really the structure of religious worship. So we stayed the direction for carbon dating, because we said this must await the evidentiary trial in the course of the proceedings. And since worship was going on in the cellar, we allowed the worship in the cellar to take place by the Hindus so that a degree of balance was maintained. We allowed worship in the mosque. We have allowed worship in a cellar where the points of access are completely different to obviate any controversy.
So you maintain status quo.
And we have maintained the degree of balance.
Yeah.
Now, maintaining this degree of balance is crucial to preserving the character and fabric of our society. That's one aspect. The second, which I want to tell you about, is that, Ayodhya dealt with an exception. Section 5 of the Places of Worship Act says that nothing in the Act will apply to the site which is called as the Ram Janmabhoomi Babri Masjid site.
Yeah.
That's the way the 1991 Act refers to it. And therefore, it creates a specific exception in regard to Ayodhya.
Yeah.
So there was absolutely no dispute that the suits in Ayodhya would have to proceed, because that's what the Act itself says. Now, coming back to your question, during the course of an argument in a court, there's a free-flowing dialogue between judges and lawyers. I asked a question in the court, in the Gyanvyapi dispute. I asked a question in the court. The case is still pending before the court. We have not passed an interim order, right, by virtue of which we have actually given vent to that question.
Yeah.
That question remained a question. If you prevent judges from discussing issues which arise in the context of a case, I think that will be all to the detriment of the cause of justice, because you must allow this free-flowing dialogue between the court and the lawyers. Now, coming to the Place of Worship Act, what does the Place of Worship Act do? I'm not going to comment on the merits, because let the Supreme Court decide that. But I must tell you, because it's very important.
Yeah.
The first part of the Places of Worship Act says that the religious character of a place, no person shall convert the religious character of a place from one religious denomination to another. That's the first part of the Act, Section 3. The second part of the statute, Section 4, says that the religious character of a place as on the 15th of August 1947 shall be maintained as it is. I'm placing it in very simple terms. That's the second part, Section 4. Now, Section 4 has itself an exemption. Section 4 says that nothing contained in subsection 1 or subsection 2, that is, nothing contained in the previous provisions of the section, shall apply to any structure of historical or archaeological significance. Right? So that what the Act does on the one hand is, though it maintains the status quo insofar as the religious character of a place is concerned, the Act itself has an exception in regard to structures of historical or archaeological significance. And then finally, Section 5 creates an eo nomine, as we say, a named exemption in favor of the Ayodhya dispute, because suits had already been filed and suits were pending. Section 4 also says that any suit which has been filed will abate and no new suit will be filed. But then comes the exemption. The question which I asked was therefore this: once the statute, the Places of Worship Act of 1991, itself contains an exemption in regard to places of historical or archaeological importance, which means essentially a monument which is more than 100 years old, because that's the Archaeological Sites and Remains Act and Monuments Acts of 1958, which puts this benchmark of 100 years. Would a survey to determine whether it falls within the exemption be barred? That's the issue which is to be decided by the Supreme Court. That's the question which I posed. If I didn't pose the question, obviously, I would be not raising a fundamental issue. Now, if a judge raises an issue which squarely arises from the text of a statute, is that in itself wrong? I mean, you have to have that discourse in a court. That's the distinction between the world of politics on the ground and a court. In a court, there is a reasoned dialogue. You're unraveling, I may be right, I may be wrong. A lawyer is entitled to say, no, judge, your prima facie question, I have a different view for this particular reason. A lawyer is entitled to say that. The other side is entitled to say, no, I maintain that, this is the correct interpretation. It's out of this conflict, not conflict in a sense of conflict, but this opposition between two divergent voices in court, that a synthesis emerges.
I understand, but sometimes there are consequences to a judgment. You or any other judge is doing the best that they have estimated in that context, applying the law. And then you see something like a Sambhal flare up, and you perhaps pause and you say, okay, could I have done this differently? I know it's not an easy job, and these are very, very complex decisions. It's like people ask journalists all the time, oh, you did this and this was the consequence of your story. And I always say, well, we had to be true to the story in that moment. We can't control the consequences. But I'm just wondering how you think about the consequences.
Barkha, the consequences, consequences have to be handled by the executive,
right,
by the law enforcement machinery to preserve peace. We have to apply the law as it appears to us correct as judges. And the duty of every court is to apply the law as it appears or as it has been enacted. The preservation of peace within society is a broader function of civil society and the constitutional authorities which are entrusted with the duty to maintain peace, law and order. But surely, asking a question in a court cannot be targeted as something amounting to a final expression of opinion or something which has caused a wider sense of disquiet. In fact, if you look at the orders which have been passed in Gyanvyapi by the Supreme Court has ensured that a degree of balance is preserved. And that balance, to my mind, in a multi-religious society is crucial. You have to preserve the balance between all faiths. We can't not look at the faiths of a cross-section of our society. And we've tried to do that. And ultimately, the test is the status quo, which is continuing in the Gyanvyapi area itself.
Talking about multi-religious society and the pluralism of the country that we live in, as a judge, how do you navigate faith? And I ask you this because, as you know, when you mentioned that you prayed to the deity before the Ayodhya verdict, there was a section of people who said that in itself is a conflict of interest. My question to you is a little more deep. My question is, you have your faith, but you're also the custodian of securing the constitutional protection and equality to people of all faiths. What can faith mean to a judge? Does a judge leave her or his faith at the door when he or she steps into the courtroom?
Right. First and foremost, the premise.
Yes.
I didn't say that I prayed to the deity, into invert commas, to the deity before I decided the Ayodhya case.
Yes.
That's not what was said. I think this is a very unfortunate translation of what was said in Marathi to my village audience. I'll come to what I actually said if it's necessary to do that. But since your question is very fundamental, let me attempt to answer that question. What is faith? Our constitution it's not an irreligious constitution. Our constitution does accept the importance of religion and faith in the life of the nation. We do not have a clause like the American Constitution. The American Constitution has two clauses, the free exercise clause and the anti-establishment clause. We have the free exercise clause, which says that essentially that every Indian citizen is entitled to freedom of conscience and to the right to practice, profess, and propagate religion. Our constitution does not mandate that judges must be irreligious or agnostic or atheist in order to be independent. All of us, or a large number of us, do profess a particular faith I respect them. I respect colleagues who do not necessarily follow any faith at all. There are all kinds of colleagues who make up this large mass of the Indian judiciary. But what is faith, Barkha? Faith essentially teaches us that all of human life, for that matter, all of nature, whether it's, the animals, birds, the manifestation of nature, this is ultimately a manifestation of divinity. That you see in each individual being, a manifestation of divinity. In that sense, what faith teaches you is that there is a certain degree of universality in all forms of human life and manifestations which we find in nature, which requires me, my faith really therefore teaches me to respect every religion, to accept the dignity of every individual, irrespective of what religion they profess, and the right of every individual to pursue their faith. In that sense, that is the ethos, the fundamental ethos of the nation itself.
Agreed.
And the faith which we follow has no bearing on how we treat colleagues, friends, and for that matter, litigants who come before us. And on any day, if you see across the Supreme Court or the High Courts, you would find people of different faiths accessing justice and being granted justice across the board. And the fact that a judge professes a particular faith has nothing to do about the manner in which he would dispense justice. Now, the criticisms against me...
Were you surprised when that controversy erupted around your comments?
Absolutely. The criticisms were twofold. One, why should a judge give vent to an expression accepting the fact that they are people of faith or prayer? Second, why should you be so open about it? I think on both counts, it's most unfortunate for the reason, one, should a judge therefore be a hypocrite and say that, I don't pray? Or should a judge sit behind closed doors and pray? If it's all right for a judge to go to a church and pray, why is it wrong for a judge to go to a temple and pray? To go to a synagogue and pray? To go to a place to go to a fire temple and pray? To go to a masjid and pray? According to me, it makes no difference. Irrespective of which place of worship you pray at, and speaking for myself, but that's besides the point. I pray at a cross-section of places of worship, but that's besides the point because that's individual to me.
Sure.
But the fact does remain that, faith, if you accept, particularly in the context of our society, our ethos, our culture, is universal in character, where you see the manifestation of the divine in every individual, in every manifestation of nature in that sense. You accept the essential dignity of all forms of life, both human and non-human. And if you accept that, I believe that it's in accord with the constitutional ethos of doing justice on equal terms to every citizen who comes to court.
Now, as I'm sitting here talking to you, you have such a calm, measured way of speaking. But in court, you often lose your temper. Often to nahi, but sometimes.
Dearly?
Don't you? Or didn't you?
I think, sometimes you also...
Don't shout at me!
Yeah, sometimes you also feign to lose your temper in the court.
To maintain a certain degree
to
of...
sort of, crack the whip, so to speak, and make sure that, things don't go out of control.
Correct.
Occasionally. And obviously, you're a human being, and you sort of lose your temper.
But what irritates you in court? What really gets your goat in court?
What would irritate me in court is browbeating. Because I always felt that if any individual was trying to browbeat someone else, because, the other person on the other side is a young junior, if, there was a browbeating on grounds of gender, where you try to browbeat particularly a young woman lawyer and, use your weight as a senior male lawyer, I would really crack the whip on that. Because the key to me of what sustains the faith of people in the judiciary is the ordered dialogue. And this is something which I was fiercely committed to and send a message across that don't destroy the essential fabric of our institution, court, which is this ordered discourse, the logic, the rationality of the discourse, which is crucial. And therefore, just to give you an example, say when we're dealing with the Article 370 cases, we had a cross-section of voices from the valley. And, when we as judges sit together, having coffee in the evening, judges are discussing, so how many more are going to be arguing before you come to the conclusion? And I made it a very determined effort to ensure that you hear a cross-section of voices. And I did that in other cases as well. Allow every voice, some time. How much time to allot, again, is a matter for the discretion of the court. You can't allow everybody to argue ad nauseum, as we say in court.
Yeah.
You have to allow some sort of rationing of time. But interestingly, Barkha, there's so many cases which constantly remind you that nothing is said, nothing is complete until the last word is said. And there are so many cases in my life as a judge when I know I've changed on the last minute of that rejoinder.
Really?
Sometimes a raw junior, a young member of the bar telling you that what you felt after hearing the respondents was not quite right. Just hear me out for 5 minutes. And those 5 minutes make all the critical difference.
Since you're on 317, I was going to come to it. It's probably one of your most scrutinized, debated judgments, and it's there in black and white, so I'm not going to get into the weeds of the verdict. But the one key criticism, and I remember interviewing Fali Nariman just, I guess, a few months before he died, why didn't the Supreme Court tackle the question of whether a state can be converted to a union territory? Right? I'm not getting into all of the other things. I think it's done and dusted and, the abrogation is here to stay. But just on a point of law, do you feel the Supreme Court ducked that?
No, not at all. Sometimes, Barkha, deciding or not deciding an issue is an act of constitutional statesmanship. In this case, the government of India told us that we are going to restore statehood. We asked them, what's the position of the government? We were critical on this issue that elections have to be held at the earliest. All of us were very clear that elections have to be held at the earliest, and the democratic process in Jammu and Kashmir has to be set in motion.
Yeah.
We asked the Solicitor General to take instructions. He said, I'll have to take instructions at the highest level, quote unquote. He came back to us the next day and said that I have instructions on 2 counts. 1, elections would be held at the earliest. And 2, he said, statehood would be restored. On elections, we said we want a time frame. We said 30th September, I believe, as a time frame, and elections were held. The democratic process was restored. An elected government has come into place, not of the same party as at the center. So we were very concerned about the fact, and we were very clear about the fact that democracy has to be restored. Insofar as statehood is concerned, the Government of India, again, the Solicitor General, speaking on behalf of the Government of India, said that instructions were that statehood would be restored at the earliest possible point of time. Now, as courts, you're also conscious, Barkha, of the fact that Jammu and Kashmir is not, or was not at that point of time,
Any other state.
was not any other state. Now, we were asked, and I've been reading some of the comments in the media, what binds the Government of India to the statement which was made by the Solicitor General? Well, my answer is very simple. Constitutional governance does not proceed in an atmosphere of distrust. If you can't trust the government's law officer when he takes instructions at the highest level, whom do you trust? Maybe politics, as it is unfolding today, does not proceed on trust. But constitutional governance can't proceed on a presumption of mistrust. So in a situation like this, where the Government of India says that we are going to restore statehood at the earliest, the court took the view that we'll accept that statement. On elections, which are fundamental to democracy, we will ensure that elections are held within a time frame. Second, interestingly, I'll tell you only one thing, that for all the criticism of the court, Article 3 of the Constitution is not as clear as you would imagine it to be. Article, can I just show you a very interesting part?
Please. You also have the red covered constitution that has become such a political metaphor today. I don't imply that you're carrying it for that reason.
No.
Where does one get this from, by the way, this red wala?
This was actually presented to me by the...
Not by Rahul Gandhi.
No, by Gopal, by Gopal Shankar Narayan. I have an inscription by him over here. And, I've, it's been part of my library. Article 3A says, Parliament may by law, A, form a new state by separation of territory from any state or by uniting two or more states or part of states or by uniting any territory to a part of any state. Right? That's Article
But Parliament?
Parliament may by law.
Yeah.
Right? Now, explanation 1. In this article, in clauses A to E, state includes a union territory. Now, this provision has not been noticed in the media. But in the proviso, state does not include a union territory. That is, whose opinion do you take? Explanation 2. The power conferred on Parliament by Clause A includes the power to form a new state or union territory by uniting a part of any state or union territory to any other state or union territory.
So Parliament does have the capacity to do this.
That's right. Second, Barkha, another very important aspect which perhaps has been missed in much of the comment in the media is that the Constitution as it was originally framed contains Article 356. Now, once a proclamation is issued by the President under Article 356, Article 356 1A postulates that all the powers of the legislature of a state shall be vested in Parliament. In other words, all the constitutional powers which belong to a state legislature upon a proclamation under Article 356(1) vest in Parliament. They are capable of being discharged by Parliament. Now, this is the provision of the Constitution, the original Constitution.
So you're saying tomorrow the Parliament could technically decide that, I don't know, Kerala is a union territory?
No, I'll tell you one thing. Sometimes constitutional statesmanship lies in allowing things to be where they are, and we accepted the assurance of the union government that they will restore statehood and that the conversion to the status of a union territory was not intended to be a long-lasting solution, but it would be restored at the earliest possible point of time.
In other words, you're actually saying that the statesmanship perhaps lay in not getting technical, because if you'd got technical, the Constitution does have a provision that Parliament can do this.
Our Constitution, Barkha, has given very wide powers to Parliament.
That's right.
Because the Constitution was framed at a time when there was fear of the survival of the Union itself.
Yeah.
You have to understand the political, the historical ethos, the historical circumstances undergirding the adoption of the Constitution. So our Constitution, when it was framed with an emphasis on a strong center. And the object of creating a strong center was to ensure that the Union would be preserved. Particularly in the context of what had happened immediately before the framing of the Constitution, partition, and the whole history of the freedom struggle. Now, if you have this Constitution, which we have given to ourselves, and it's a Constitution which has remarkably stood the test of time, it's also important for courts as constitutional authorities to decide some questions, at other times to allow for things to be as they are and accept a solution which would ensure, in this case, the restoration of statehood.
Yeah.
So the fact that statehood has to be restored is now an accepted position, because that is what has been recorded in the judgment of the Supreme Court.
I understand.
Having said that, there were reasons perhaps which may have weighed with the court to accept the statement of the Union of India. As I said, Jammu and Kashmir is like no other state. We have a history of cross-border terrorism. And I think the fact that democracy has been restored in the state of Jammu and Kashmir, that you have an ordered transfer of power to an elected state, into an elected government in Jammu and Kashmir, is itself an indicator of the constitutional process having taken fruit. And hopefully that's part of the continuum to eventual restoration of statehood.
Your other seminal verdict was on electoral bonds. Were you, while delivering it, worried about displeasing many powerful politicians?
Well, if you were worried, Barkha, if you were worried about displeasing anyone, why would that verdict have come? I mean, the very fact that the verdict came is that these things are.
I know, but I'm just wondering what the mental. I'm just wondering what's the mental process. Do you block it out? It's like speaking as a journalist. Sometimes you do a story, you know that it's just going to make somebody you may know otherwise very angry, and you still have to do the story, right? So it's similar that you know that this is what you believe, you know this is what the constitutional principle demands, but you know that there could be pushback, blowback. Was there blowback?
For a judge, there's only one constituency, and that's the constituency represented by the words of the Constitution, the text of the Constitution.
Fair. On the bonds, some of your former colleagues on the bench said, why didn't the court go further? If this was held to be, if it was struck down.
Did some of my former colleagues on the bench with me say that?
No. I mean, former Supreme Court judges, not on the bench with you. Other judges who have been Supreme Court judges in the past argued that you could have gone further in terms of, then why didn't you try and crack down on those who had paid and so on, right? Like you must have seen that commentary. Do you feel that you could have done more than just saying electoral bonds can no longer be used?
Well, as you know, about the former colleagues bit,
yes,
I'll only ask some of them this question. What did you do when you were on the bench? All right, but let's leave it at that. On the other aspect, on what we could have done, the challenge before us was the constitutional validity of the electoral bond scheme, which was brought in by a parliamentary amendment. We struck down the amendment, right? We held that the amendment was unconstitutional, and we consequentially held that there should be a full disclosure of everyone who had contributed to the electoral bonds. And we said that this must be placed in the public realm. When the State Bank of India came back to us and said there were difficulties, we said, we are not accepting this. You have to make that disclosure. Now, having said that, that was all that was argued before us. Every bit of the case that was argued before the Constitution bench has been dealt with in the judgment of the Supreme Court. Namely, the challenge to the validity has been upheld. The scheme has been struck down on the ground that it allowed for anonymous political funding of political parties, which would be manifestly arbitrary. And therefore, the names of everybody who had contributed must be disclosed. And the tax exemptions which were granted to contributors would therefore stand nullified. The do further came in the form of another petition later.
Right.
When we struck down the scheme, that was all that was argued. And
that was not before you at all.
Absolutely. That came in later on.
Got it. Now, towards the end, though I have so much to ask you, but towards the end.
And should I also add something about, why we didn't do further?
Yeah.
That again, Barkha, constitutional adjudication is not a simple process. People contributed. In round 2, we had a petition which said that constitute an SIT, constitute a special investigation team, and criminally investigate every donor who had donated monies as part of the electoral bond scheme. We didn't accept that.
Because that's not fair, right? Because the person donating is doing it thinking it's lawful.
Barkha, it's a very important point that you've made.
Yeah.
You've made a very, very important point. There are 2 points, which weighed with the court, which the order of the court speaks. The first, constituting a SIT is an exception to following the normal processes of the criminal law. Normally, anybody who feels that, an offense has been committed has remedies. You lodge an FIR. If an FIR is not registered, there are remedies under the law, so on and so forth. Going to the Supreme Court directly and asking for the constitution of the SIT is to obviate complying with the normal processes of the criminal law. which the court should not allow as a matter of first option. It's done in very, very rare cases. Second, another important thing is what you said, which is that, well, we struck down the scheme. We denied the tax exemptions. We asked for disclosure of information, let the people know who had contributed. The second point is that there was no challenge per se to corporate funding of political parties, which has been part of our polity for almost 60 or 70 years. There was no challenge to that even today of corporate funding per se. In fact, one of the arguments in the court was that nobody contributes merely out of altruistic motives.
Of course.
Right? Even when you place money before God, the bhakt always accepts, feels that, I'll receive some blessings on a lighter way. But, interestingly, look at it this way. You have a law which is enacted by Parliament. We are a responsible republic. A 75-year-old republic. Parliament has enacted a law. People act in pursuance of the law, albeit business houses. But let's not be hypocritical. Business today is also the source of productive employment, generating revenues for the Union of India and for the entire nation. To what extent do you pursue this? Do you pursue people who, acting on the strength of a law enacted by Parliament, have contributed? Would that impinge upon the faith which people have in the political system, in the maturity of our system? So when you take decisions as courts, these are not simple decisions. Have an SIT, don't have an SIT. But obviously, these are factors which weigh in the balance when you take constitutional decisions.
Absolutely. Now, how do you manage an ethical, appropriate relationship between the judiciary and the executive, right? This becomes an important question in the light of the debate around the collegium. How hard could you have pushed? There were certain transfers, for example, that were recommended, or government just sits on the file. There are certain judges recommended, Saurabh Kirpal. File comes back, it's sent back, government sits on the file. There was a very public, vitriolic commentary on the collegium system at a point when we had Mr. Rijiju as law minister questioning the entire collegium system. I'm just wondering, when you look back at your tenure, do you think you pushed as much as you could on the appointment and transfer of judges?
Barkha, you asked me about the relationship between the ethics and the relationship between the government and the judiciary.
And as you know, there was so much commentary when you met with when the Prime Minister met with you for a puja.
There are two aspects. There are two aspects which have to be emphasized. First is the relationship between the court and the government as the largest single litigant in the judicial process. The largest single litigant today in India is the government. Whether it's in terms of, the social welfare laws, labor, tax, just the whole gamut of laws. In the work which judges do, there is absolute independence and a clear difference between the government and the judiciary. Both the government and the judiciary are part of the nation state, but these are two distinct wings of the nation state. The executive, the legislature, and the judiciary, the three wings. In the work which courts do, there is an absolute and clear demarcating line between the government and the courts. And the surest test lies in the question which you asked me about the electoral bonds. The courts have taken and continue to take decisions which will go either way, and that is itself a sign of judicial independence. On the administrative side and on appointments, the position is much more nuanced, because both the government and the judiciary are vital stakeholders in the process of appointments. They are vital stakeholders not merely from a public policy perspective, but from the constitutional perspective, and particularly as the Constitution has been interpreted in the judges' cases, where the appointments are routed through the judiciary, but ultimately the government has its own inputs. Now, this is an area where there obviously has to be a dialogue between the government and the judiciary, the Chief Justice of India. I remember in one of your segments when you were interviewing Fali Nariman,
Yes.
was a great mentor to me.
Yes.
I really
Great guy.
I miss him. Great person.
Yeah.
Fali said that, well, why is the Chief Justice not engaging with the Law Minister? I remember his words in that interview.
I do remember.
And I never went and told Mr. Nariman because, I respected him too much to even, hazard, a conversation with him on this. But, well, the point of the matter was the Chief Justice was in active engagement with the Law Minister.
Yeah.
And the Chief Justice of India has to be in active engagement with the Law Minister on making appointments. And this is the position both before the collegium system came into operation and post the collegium system coming into operation. There are obviously differences in perspective. And we have to, as mature statespersons, we have to accept the fact that there are differences in perspectives. Now, it is because there may be differences in perspectives that you have to have this dialogue when a file is held up. And during my entire tenure, whether it was, Mr. Rijiju or Mr. Arjun Megwal, I was in constant conversation with the
Law Minister.
With the Law Minister that, you say that, well, Law Minister, these are the appointments to the High Court. So many appointments now, they're in the pipeline. Something has been held up, say, at the level of the IB. When is this going to be completed? And you're continuously reviewing the work.
But when they continue to just sit on it, what can a judge do?
Well, the judges, the decision in the judge's case mandates that once a name has been reiterated by the collegium, that binds the government.
Right.
Well, that is the position of law. And if certain names have been reiterated by the collegium and appointments have still not been made, that's for the government to explain.
You can't summon somebody in the government.
You engage with the government. Summoning is when you sit as a judge.
Yeah.
When you sit
as a judge, is it contempt of court? I'm just trying to understand the position that if you reiterate the name, which is, I think, what happened with Mr. Kirpal, and then there's no movement, then is the government in contempt of court?
Barkha, I have a different take on this whole issue of contempt jurisdiction. My take is very different. The judiciary, as well as the government, are constitutional stakeholders in the process of judicial appointment. Each of us have an assigned role. The power to exercise the contempt jurisdiction is a power which must be exercised extraordinarily sparingly. Particularly in these contexts. For the simple reason that we are a stakeholder in the constitutional sense. We have a vital role in the constitutional sense. If the judiciary uses the power of contempt to get its own way through, there would be some issue on that. Should you be using your judicial power to punish for contempt?
I see what you're saying.
To really push through what someone may say your agenda on the administrative constitutional side. That is one. Second, the better answer in all these cases is to engage in ongoing dialogue, ongoing statesmanship, and virtually by the week, if not by the fortnight, I would be in engagement with the Law Minister, reviewing vacancies which have to be filled up, reviewing files which are cleared, pushing certain files which have to be cleared because somebody's term as an additional judge is coming to an end. You have to tell the government that, well, we have to do this quickly because somebody is retiring as an additional judge. Particularly this happens in the context of the service judges who come into the high courts. So there are a range of issues, some of them which are vexed, others which are more routine. But speaking for myself, we have done one of a couple of things. We have been putting out, at least during my tenure, the reasons for the decisions of the collegium.
You made it quite transparent,
And therefore, the reason why we felt that Saurav Kripal's appointment should be made was put up in the public realm.
Absolutely. And I think that transparency is a big part of your legacy. Live streaming of proceedings, the fact that we can watch you sometimes say, don't shout at me and chuckle to ourselves. But more seriously, do you feel when you look back that transparency was one of your biggest achievements?
I think so, yes.
Yeah.
And I placed a great deal of importance on live streaming. Not because I'm a geek on technology. I'm fond of technology.
Yeah.
I don't claim to know everything. I mean, nobody can in today's world.
But why didn't you allow live streaming of everything? Why just constitutional benches?
I'll just come to that in a moment. The importance of live streaming is that it has enabled the court to take its proceedings to the homes and hearts of people. And it's promoted a degree of confidence when people look at what's happening in the court and they realize the seriousness with which small cases, individual cases are taken up by the court. That sends a message that, look, this is an ordered dialogue happening in the court. We may be right, we may be wrong. It's a human process. I'm not on the merits of any decision. But the fact that, individual cases of our citizens command that much of serious dialogue in the court sends a sense of confidence in the process, in the judicial process. Because ultimately what sustains the judiciary is just faith. You don't have the power of the purse or the sword. It's the faith of people. So I think live streaming in that sense has been a great game changer. Apart from that, it's promoted accountability. Very often courts are targeted on the ground that, well, this is Tariq pe Tariq, that you've been granting adjournments. I felt, let the people know why cases are adjourned in the court. Who asked for adjournments? Let people know. Let that be up in the public realm. Sometimes it's more difficult to get a lawyer to argue a case than to decide the case for a judge. And third, accountability on the part of the courts themselves. Are you sitting all day in court? When the high courts, have been live streaming, just the fact that you click and find out whether that judge is on duty or that judge has just got up at 2:00 and gone off, from court. So from all perspectives, live streaming in that sense is, center of transparency.
It's a great contribution. And
you asked me, Barkha,
why didn't you apply it to
all other courts? There was a technical issue. When we started, the infrastructure for live streaming was really implemented. We had it already in place as part of the e-courts project, which I was chairing through my last 5 years or so. But COVID really was a game changer when we, had to have, online and remote proceedings. Now, we had to create capacity. Live streaming for all courts has a tremendous burden on capacity. Right? Now, we had to have which means budgetary outlays.
That's right.
We got phase 3 of the e-courts project sanctioned by the government, pursuant to an all-party delegation of the Joint Parliamentary Committee. The Parliamentary Committee on the Department of Justice came to the Supreme Court. They were very gracious. They didn't ask me to go to Parliament House. They said, we don't want the judge to come here. We'll come to the Supreme Court and engage with the judge. And they actually saw for themselves what our mission was. And they recommended to the government that our budget should be cleared. We now have a budget of 7,000 crores as part of the e-courts project. Now, we have now utilized that budget to set up the cloud infrastructure because to live stream every court has a tremendous, you need the infrastructure in place. So the whole process was part of creating this robust platform. Now, the first 9 courts, I believe, in the Supreme Court are equipped to be all digital courts, paperless courts. You have live, you have these large screens, where you can have video conferencing facility. It's also been a great leveler. I find that more and more women have been appearing in courts because for women, it's very difficult to, women typically in our society have so many different responsibilities and roles. So to sit in court and wait for the whole day for your case to reach is just not productive enough. It's not productive enough for men, but particularly for women because, they're looking after families, a whole lot of other responsibilities. So it's wonderful to see young women lawyers, appearing through video conferencing so that they can spend their time in office.
But do you hope this will address the backlog? I mean, something we haven't spoken about is judicial reform, right? Backlog, the fact that we need more judges, we need more courts.
Barkha, my solution is very radical now that I have left the judiciary.
Which is?
So long as I was a judge, I had to be a soldier within the system.
Yes.
But unless we bring about structural changes, the backlog is not going to be addressed. We are asked, why don't you scrap vacations for courts?
Yeah.
And I always say that, look, there are always partial court vacations or partial court working. All right, suppose you scrap working, you scrap vacations. Last year, we had about 61,000 cases filed in the Supreme Court. 59,700 cases were disposed of, all by 34 judges. So we had just a deficit of about 1,000 or 1,400 cases, notwithstanding the fact that we had constitution benches going of 5, 7, 9 judges. Now, the fact of the matter, Barkha, is this, that we have placed too much of importance, particularly in the Supreme Court, on oral advocacy. And we have to confront ourselves with this. People will say, well, why don't you appoint more judges? We are 34 judges now in the Supreme Court. All right, you make them 38. What happens then? 29,000 cases were filed in the Supreme Court right after COVID. Between COVID and now, the 29,000 has gone up to 61,000. 61,000 is going to become 70 or 80,000. As society becomes more prosperous, people become more rights conscious, that's going to be increasing. If every case which comes to the Supreme Court has to be orally heard, you're staring down the barrel. And we need to have structural changes within the Indian judiciary if truly we have to answer the question of backlog. The district judiciary. Appointments to the district judiciary are made by the states.
Yeah.
That is by the governor in consultation with the high courts.
Yeah.
Now, there are large vacancies in the district judiciary, which is the base of the pyramid. And there are about 21% vacancies in the manning of judges in the district judiciary, 27% in the administrative staff of the judiciary. Now, if you have to truly find an answer, we need to think of more out-of-the-box solutions. Can we not think of an all-India judicial service? You can preserve the concerns of the states in a federal setup. The states are concerned because they feel that if you have an all-India judiciary, a district judiciary, that will affect the powers of the states to recruit, and they have their own reservations in the states. Right. But what if we have one examination for recruitment to the district judiciary?
Absolutely.
And then the states can recruit from within that merit list, apply their reservations. Every state has different reservations within that list. So, I think the time has come now, 75 years after independence, to take some very hard decisions, particularly in the context of the Supreme Court. Should every case be heard at the stage of oral argument? A second appeal, a civil case which has gone up the ladder, does it have to be heard orally? There are very few Supreme Courts in the world which do the kind of work which our Supreme Court does. And I know how completely overwhelmed and stressed our judges are. But I'm not about just judicial stress or judicial fatigue. I'm about, the danger of our system becoming dysfunctional. Our access to justice model has been so broad-based that we virtually allow anybody and everyone to enter the doors. At some point of time, we have to address this fundamental issue. Are we not going to apply the brakes? If you're not going to apply the brakes, there's a grave danger that the system will become dysfunctional.
Yeah, I hear you. What about when a judge becomes a point of controversy to the extent that his or her utterances are seen to be anti the Constitution? I'm talking in particular about Shekhar Yadav, someone that you actually said was not fit to be appointed as a judge. He's a judge. He has made a public speech that is widely seen to be communal, polarizing, and not within the framework of the Constitution. Now, how should the Supreme Court respond in a case like that? Because he's been defiant. He was asked about his comments. He said, I did nothing wrong.
Now, in the existing structure which you have for disciplining cases, the authority of the Supreme Court in that sense is also clearly defined and to a certain extent limited. The power which the Chief Justice has is essentially to start an in-house inquiry.
Yeah.
Right? And that's the course of action which is open to the Chief Justice. And I believe, from what I gathered from an interview with Justice Rishikesh Roy in the electronic media.
I saw that, yeah.
I believe that the Honorable Chief Justice of India is in the process of doing that. I haven't got any authentic information on that in terms of,
checking
an
it
official
yourself.
or an official statement.
What would you have done if you were Chief Justice today and this case came up? What would you have done?
Well, there are 2 or 3 things which you can do. Apart from the in-house inquiry, I had situations where there were comments by a couple of judges in the High Courts, which I thought were unfortunate. Comments made while they were hearing a case.
Yeah.
And I thought it's important that we take it head on because we not merely have to take action, but we have to share with society at large that we look at this very seriously. And therefore, we took it on the judicial side. We asked the Registrar General of the High Court in that particular case to verify from the judge concerned as to whether such a statement was in fact made, because there could be misreporting.
That's right.
Even a video clip can be doctored.
Yeah.
After the Registrar General of that High Court came and reported back to us, we delivered a short judgment saying that this was not on and this is not acceptable. And we thought that will send a message across the Indian
Do you think that should
judiciary.
happen here?
I don't want to step into the shoes of the Honorable Chief Justice of India. I know what a difficult job it is.
Yeah.
There are different views, perspectives. You have colleagues you are continuously discussing the matter. I entirely trust the Chief Justice of India's experience, his discretion, his very studied application of mind to the case. So I'm not going to take that call for the Chief Justice of India. But these are the 2 or 3 options, the 2 options really which are open to the Chief Justice.
Now, as we end, a little bit about you, the person. You didn't want to be a judge. You went to college, St. Stephen's College, and studied economics.
Yeah.
How did you end up here?
I don't know. when you
Serendipity, accident.
Yeah, I mean, Barkha, when you begin life as a young lawyer at the bottom of the ladder, and you're appearing with seniors. I had the joy of appearing with Fali Nariman, Soli Sorabji, Ashok Desai. You never think about, if you're going to become a judge or,
But you weren't even going to be in law.
I had actually decided to join the Delhi School of Economics because I stood first in my BA in economics from St. Stephen's College. And the law fac, as we used to call it, started earlier.
It's still called just law fac.
So I joined the law fac, and then there was just no going back.
Yeah. But did your father, who was also Chief Justice, tell you that you have to be a lawyer?
No, not at all. I think, he was in that sense, what we call in Marathi, Sthita Pradnya. Sthita Pradnya means, somebody who is to himself and,
kind of measured.
Measured. If I had a problem, he would always be there for me if I asked him something, but he would never volunteer.
But he was okay with you not being a lawyer?
Oh, absolutely. In fact, even when I was asked to become a judge, my appointment was not coming through. I was asked, I think in the sometime in 1998, and it was early 2000, and there was no sign of our appointment coming through. I believe,
Sounds familiar.
And at that point, there was an objection. We were 3 of us, Justice Bobde, Justice Khanvilkar, and me. And I believe one of the objections was that all 3 of us were much too young. And at some point of time, I went to the Chief Justice and I said, Chief Justice, will you please relieve me of this burden of endlessly waiting for my appointment? So he said, give me a week and I'll come back. And if there's no resolution, then I leave it to you. Because I had a serious personal issue at home, and which I had to attend to spousal health at the time. And my appointment came through in the next week. So, life takes you along paths which are uncharted. You never imagine that, you'll land up where you'll land up. But that's also a sort of a cause to be humble and to, it's a sobering reflection. There are over 1,000 judges in the high courts. We're a country of 1.4 billion. One person becomes a judge, a Chief Justice of India.
So if you hadn't been a lawyer and a judge, you would have been
I wonder.
An economist, you think?
Yes, an economist. Yes, an economist. Even now, I love to read on economics and history. And
what's the last good book you read? Don't say the Constitution. Or do you get time to read it all?
Yeah, I'm reading William Dalrymple's latest book right now. I've been reading Yuval Noah Harari. I read multiple books at a given point of time because I feel, reading one book through cover to cover tends to get you a little
same
tired.
here. I read many books in
parallel. So I've been reading Yuval Noah Harari at present.
Yeah.
And I've been reading a very interesting account of Constitution, which is not, by the way, serious constitutional stuff, but very profound in its own way. Lots of humor, which is a year of living constitutionally. And someone who decides to live the life of the founders of the American Constitution right in the present age.
How interesting. Now, this conversation would not be complete without talking about your wonderful daughters, who you say have changed how you look at the world. They've made you vegan to start with. And that's very serious. I had I've had opportunity to sample some of the vegan fare here, and it's absolutely wonderful. But you have extended it to not wearing silk, leather. You really believe in it. And is this the impact of your daughters?
Yeah, actually, Barkha, this is completely the impact of our two girls, Priyanka and Mahi. They're both special needs children, but they are fiercely active in the space which is close to their heart, namely the environment and the ethical way of living. And for the last decade, they were after us to both after Kalpana and me to become vegan and to follow the lifestyle which they wanted us to follow. And eventually, my spouse Kalpana first became a vegan, and I followed suit. Being vegan is not just a matter of having a plant-based diet, but it's also about how you live your life in general, what you wear. It's all about, the ethical treatment of every living creature. And it's a tough call. So I've taken a call that, I'll not buy any new products which are not vegan. Likewise, my wife is also taking the same call because you have so many things at home and you don't throw them out merely because you've gone vegan. It's also a question of budgetary resources, right?
Of course.
Especially if you have been in services, I have been. And but it's also about, I think it's just a reminder that, the earth and the planet is for every species. So we are not as we say in the law, we are not dominus litis, that we're not the dominating species.
That's right.
There has to be an acceptance of the fact that the earth is made of every conceivable creature in the planet.
And did the girls also make you much more sensitive to and aware of special needs, the rights of the specially abled?
Absolutely. In fact, I think as we evolve in life, it's our experiences of life which change us.
Yeah.
And I think both my girls have really changed the way I look at not just disability in general, because disability, yes, because I've realized that, people who are differently abled have their own aspirations and, their own concerns. They need to have dignity, whether as
and not
young
be
children,
pitied or not be treated as charity cases.
Exactly.
Yeah.
If I go into Mahi's room and, she's on a bed or she's on the floor playing or, working on something, and I ask her, should I give you a hand to help you into the wheelchair? And she said, no, it's okay. I'm going to do it on my own.
Absolutely.
And I might just stand away and just keep an eye on her, but I want her to do it on her own. So, their quest for leading equally fruitful and productive lives is very crucial. And that's what, my association with them over the last decade has taught me. But also in general, not just in terms of how you view disability, but in terms of allowing others to, lead their own lives and allow them to lead happy lives without pitchforking what you think is the appropriate way of living into the lives of others.
Yeah.
Allow people to, be happy the way they are, even if that
I think you said somewhere that your big philosophy is to live in the moment.
Yeah.
So while you're living in the moment, what are you going to do now that you're retired? Everybody wants to know.
Well, I've been enjoying, Barkha, traveling the country.
Yeah.
Earlier, I could travel basically for official duties, which meant that so many other invitations, which I would love to have accepted.
You'd have to decline.
I had to decline just because of the pressure of time.
And you could finally have a social life and meet your friends and other people.
Absolutely.
Right?
I've been traveling a lot, going to colleges, meeting young people. addressing diverse audiences. I've also been doing a little bit of private work as well, because I have to keep mind, soul, and body together. 25 years of judging means 25 years away from
lucrative practice.
So, I mean, there's a limit to it as well, but I have been doing some private work as well, but combining it with other things. And I hope to be teaching a little bit, maybe teaching some short courses, working on that, writing, hopefully writing a book.
You have been one of our most prolific judges. Please correct me if I'm wrong, but I think Vidhi Legal Policy said that you wrote 93 judgments in your 2 years.
I haven't kept count.
Well, that's what they counted, 93, which is a lot. And you have been part of not just chronicling, but shaping the history and the future of this country, which is extraordinary. Thank you.
Well, I happened to be at that place at that time, and I try to do it to the best of my ability.
Well, thank you, Justice Chandrachud.
Thank you so much.
It's been a
Barkha.
pleasure.
Thank you so much.
Thank you
Thank you so much for having this dialogue with me.
Thank you.
Thanks.